Earlier this month, the father of the Appalachia High School shooting suspect was arrested in connection with the shooting that left 4 people dead. And in April of this year, the parents of a school shooter in Michigan were sentenced to 10 years in prison after their 15-year-old son killed 4 people and injured 7 others. These high-profile cases against parents have raised serious questions in the legal world over the responsibility of parents, the burden of proof to show that the action of the parents were negligent, and what other crimes parents could be charged in connection to. Joining us now to discuss this is criminal defense attorney Jerry Buting. Jerry, thank you for joining us.
Good to be here.
Now, charging parents in school shooting cases is a fairly new development, and people are arguing over the fairness of this. What do you make of that?
Well, it's fairly new in some ways and not so new in others. Parents have been held criminally responsible for negligence regarding their children really for about almost 100 years in America, but it varies from state to state, and it's only very, very recently that these laws have been applied to school shootings, where parents are now being held responsible for allowing their children maybe to have too much access to guns. And I think that it's born of a frustration in a lot of states anyway about these mass shootings and an inability to do anything to prevent them. And when they involve children, who are particularly children who are still in the home, then it raises a lot of concerns with the citizens in these states about how can we stop these shootings.
Now, in regard to this affecting different states, I know right now 42 states, I believe, have this charge where parents are getting charged for negligence. Do you think the other states will kind of follow suit and this will become a U.S.-wide thing?
Well, I don't know if they're all going to follow suit because, in America, it's 50 different states, 50 different governments, and different people feel strongly about this, but even some so-called, red states in America have passed laws like this, although they haven't yet been applied to individuals. And one of the problems that you have is that it gives a lot of discretion to the prosecution. Ultimately, when you get right down to it, it's going to be a fact-based decision that a jury is going to have to decide. But before you even get to that point is the prosecutorial discretion that's exercised. And some people have been concerned that, that some prosecutors don't demonstrate the best discretion. The old saying, if you give somebody a hammer, everything looks like a nail. And, I've certainly encountered prosecutors like that in my career, where one prosecutor has charged a particular fact situation as a crime when others may choose not to.
Now, as a defense attorney who's represented clients in high-profile cases, where does the court draw the line with charging parents with negligence? Does it just stop at gun violence, or does it continue with armed robbery or drug possession and things like that?
Well, arguably, that's one of the problems. Where do you draw the line? Decades ago, some states started what they call the dram shop laws, which were where you would prosecute parents who allowed their minor children to have access to alcohol. They went off drinking, drunk driving, killed somebody. And, there are some states where those kinds of prosecutions still do take place. Other states have had very strong tavern league, alcohol lobbies, like my state in Wisconsin, and those kinds of laws have been prevented from application in the criminal context. You can still be held liable civilly, but so it's hard to say where the slippery slope that we're starting on will end. Could it be armed robberies? Could it be, you know, uh, really anything when a parent is responsible for a child who then goes off and commits some sort of criminal act?
Now, we do just have under a minute until break, but is the burden of proof different in a case like this?
Well, the burden of proof would be the same, and it really depends on the type of charge that's issued. So if it's a involuntary manslaughter, many states have a gross negligence standard, which is to say that there's still a mens rea or a mental state component where the parent has to have some sort of willful knowledge about a a risk that they're disregarding by allowing their child to have access to firearms, particularly if they know that the child has mental health issues and they still permit that. That can certainly constitute gross negligence.
Welcome back. I'm just picking up with Jerry Buting where we left off. So, some who have argued in favor of these types of charges have said that this will signal to parents that they need to take more responsibility. Do you think this is accurate?
Well, of course, that's the big question. Will parents be deterred from leaving guns unattended, or allowing their children to have access to firearms, or in buying them an AR-15 when they're 15 years old, for instance? Is this enough to deter parents from that kind of conduct? And there, the whole question of general deterrence is sort of assumed that people are deterred by criminal charges that are possible, but there's not a lot of evidence of that. The real thing that deters people is the risk of getting caught and prosecuted. It's not just having a law on the books. So I would say it's questionable whether this will really modify much behavior. I mean, those parents who tend to be responsible and likely to be deterred in the first instance probably already are. And those who aren't, this kind of law on the books probably isn't going to make much difference.
Now, I'm wondering, obviously, this will be a case by case situation, but in the two cases that I touched on earlier, the parents were responsible for buying the child the gun. In a case where the parent doesn't buy the child a gun, will they still face negligence charges, or again, is that case by case?
Well, there'd have to be some unusual facts, I think, if to prosecute a parent who doesn't know, who doesn't buy a gun, and their minor child, obtains possession of a firearm somewhere. But they're trying to pigeonhole these cases into common law homicide type, murder cases, felony murders, or involuntary manslaughters. But there's also contributing to the delinquency of a minor charge that again, it does require some kind of reckless behavior, even though it doesn't require the same willful intent on the part of parents. So if they didn't buy the gun, but they were aware that their child possessed the gun, it did nothing to try and protect the public from harm that could come from the gun, then theoretically, yeah, they could be prosecuted under contributing to a delinquency of a minor.
And do you think that the resolution to prevent school shootings is to continue to charge parents with negligence and hold them more accountable, or is it to raise the gun license age in the United States?
Well, it could certainly be raising the age. I think they've had legislators have had and gun lobby reform, I should say, gun reform advocates have had a real difficulty passing laws, even red flag laws. Some states it's very difficult um, to pass because of the very strong feeling of gun lobbyists and lawful gun owners that they believe they have a constitutional right to possess arms. So I think these cases, these charges are coming out of the frustration that some people have at the inability to prevent these kinds of incidents from happening in the first place. And um, yes, we could certainly raise the age of possession, lawful possession of a firearm to 18 or to 21. And that might, reduce some of the criminal mass shootings that we see in this country. But of course, it's not going to remove all of them, because mental health is a serious problem as well, and that can affect people at any age.
Jerry, thank you so much for the time today.
You're very welcome. Thank you.